Alright folks, it's been a while since I've put out a video. I wanted to give a quick update here. What we have here is somebody I've covered in the past uh, who made threats to law enforcement on his Facebook page. Imagine using Facebook in 2020, 21, or 22. Anyways, he's been on an ankle bracelet. Why? I have no idea why he's not sitting in prison right now, but somehow he managed to weasel his way and e-bag, and the community has supported him for some reason after he made these threats, saying that he would like to see a police officer in a casket. Now, we know people on this channel that we've covered that have made far worse threats towards law enforcement, and they are still out roaming free. But this one is in front of the court, petitioning because he has not only a state ankle bracelet on, he has a federal ankle bracelet on, and in my opinion, that's not enough. He should have two on his wrists as well. Maybe put him in some torture cuffs. Really don't like this guy. You know that he's just having a great old time now that the Supreme Court has taken away women's rights. He's that guy that I've covered before. He's a real douchebag, and he's a career criminal. Can't keep himself out of trouble, and indirectly or directly makes threats towards law enforcement. And he's sitting with two ankle bracelets, and so now he's going before the court with his sovereign citizen attorney. I believe this guy is called ANCAP something, ANCAP Cop Watch or some shit. And if you're not familiar, ANCAP is anarchist capitalist. They're the Proud Boys, the January 6th insurrectionists. They're basically sovereign citizens, libertarians. And so let's get into the court case.
Page 35, Your Honor. C-21-353-951-1, State of Nevada versus Joshua Martinez.
Good morning, Your Honor. Ed Keach on behalf of the state.
Good morning, Your Honor. Augustus Claus appearing on behalf of Mr. Joshua Martinez, who is here telephonically via, it should be a telephone connection on Blue Jeans. He won't have video, but he should be there.
Mr. Martinez, can you hear us?
Yes, I'm here.
Okay, thank you. All right, this is defendant's motion to modify bail conditions. Do you want to go ahead and go forward and make your argument?
Certainly, Your Honor. I thought it was relatively straightforward until I saw the state's 200-page opposition. I'm not sure if you've had a chance to go through that in detail. I didn't want to rehash the issues. If the court wants me to do, excuse me, I can. But as I said, I thought it was relatively straightforward. I don't want to leave the court with any unanswered questions, but essentially what we have here is a situation where when Mr. Martinez was placed on electronic monitoring by Judge Villani, the federal case did not exist. Subsequently, he was indicted in the federal system on, if memory serves, two charges. One directly related to this case charge of possession of a firearm, and then the second one of possession of ammunition based upon this state's evidence. No new conduct, just essentially moving the allegations and factual allegations from this case into a federal indictment. The judge in that case also released him on electronic monitoring. The electronic monitoring conditions are extraordinarily onerous, and more onerous than what we have at the state level. But also, Your Honor, they're conflicting. And so we've got a couple of problems here that range anywhere from the mundane to the ones that are going to ultimately cause us problems. The mundane problems, and I'm not sure if you've seen this, Your Honor, but he has two bracelets on now, one on each ankle, and so he can't have it changed from one ankle to another. So we sent photographs to both the state and to the court earlier today. As I said, when I filed the motion, I thought it was going to be relatively straightforward. But you can see the scarring, the chafing, and the welts that are appearing on his ankles because they can't change the one bracelet from one ankle and have it be on a clean ankle. So he has to have these on continuously. But beyond that, Your Honor, they also have contradictory requirements. So the federal requirements require him to come into town for UA and drug testing with less than a few hours' notice. It has to be the same day. With the state, he needs 24 hours movement notice in order to be able to come into town. So there's a conflict there that eventually we're going to have where he needs to come down and get fed UA tested, and the state EMP is not going to be available to approve that, or they're going to think that it's some form of unapproved movement. There's visits or check-ins. For the feds, they want 24 hours notice before he comes into town. The state wants same day. So they will call him, the state will call him and say, we want you to come in and check in. They want it on the same day. The feds want 24 hours notice before he's allowed to be in the valley, unless they're the ones who have told him to get there. Does that make sense, Your Honor?
Yes.
Okay. Finally, weekends. So the state is open on the weekends, and they will have EMP people who are under EMP supervision come in on the weekends on occasion whenever they feel it necessary. But the feds are closed on the weekend, so he can't even get the approval to come down if that's what the state wants him to do. So, Your Honor, those are some of the contradictory instructions that he's getting from the Fed and state monitoring. And let me be clear, as I read the restrictions and as we've submitted them to the court, they're more restrictive than the state restrictions are. It's just a matter of the two of them are restrictive in different ways. But it's also just, as I said, even mundane matters like charging the two devices, Your Honor. They can't be charged at the same time. The state device is subject to overcharging, and so he finds himself charging these devices for 4 hours each day, just hooked into a wall while these things are charging. And he can't afford to ignore them. He has to pay attention to when the state device is charging, because if it gets overcharged, that apparently causes some damage to the device, and then he's held responsible for that and has to get a new bracelet. So, Your Honor, he's having scarring and chafing and welts that are being caused by having two bracelets. He's having two bracelets that are requiring 4 hours a day in charging, and you've got contradictory instructions here. And for the life of me, Your Honor, I can't understand any of the state's argument that there's actually one whit of community safety or safety for the victims here that's being provided by having two separate house arrest monitoring bracelets on. So, beyond that, Your Honor, I want to emphasize here, despite what came out here, this contact that's been averred by the state, and as you read through their motion, I'm not sure it makes it quite clear. Yes, there was an initial contact with Detective Meade, but then Detective Meade interjects himself into my client's criminal case. There's some question as to when and how that occurs, but Your Honor, Detective Meade prints out my client's Facebook posts and then decides to show up in court in that other case number, Your Honor. That, for the record, is case number C-1732611. He's not even assigned to that case. And he doesn't email these photographs off to the DA and say, I think you should know this before you sentence this individual. He makes a point of bringing hard copies into court, and he shows it to DA Dickerson. That's where this really starts happening. There are some additional allegations here, Your Honor. For instance, that negotiation for my client was supposed to be a felony with a drop down after successful completion, but shockingly, about half a dozen probation officers show up in my client's house when he's been placed on probation for about 30 days. They find various minimal technical violations. They conduct a multi-hour violation hearing. Ultimately, Judge Barker finds that while he's in violation of his probation, reinstates him. But because of the terms of the deal, which you might have been seeing here, Your Honor, he's now ineligible for the drop-down. And guess what? No more violations for the rest of his probation. But as soon as he got that first violation, everybody was happy. And it is our belief that we will show at trial that that was actually Detective Meade's handiwork. Because during the testimony, the probation officers testified that they received a phone call from a Metro detective about this particular probationer. They didn't know who it was, but they received a phone call from this particular probationer. And so, Your Honor, In response to that animosity, yes, I have to admit Mr. Martinez has not been showing Detective Meade love. But let's be very, very clear. He has not been going to his house. He has not been stalking any of these individuals here. In point of fact, DA Dickerson, who was originally charged here, didn't even want police protection because, and we can go through this, Your Honor, we argued this ad nauseum in front of Judge Filani. There's an audio tape where my client calls into Metro Dispatch in an attempt to get in contact with Detective Meade to get the property back that the state concedes Detective Meade took from him years previously. When Detective Meade is told this, Detective Meade doesn't say, "Oh, wow, that's shocking. Oh, my heavens, this guy shouldn't be contacting me. I feel really in fear." He says, "Preserve this phone call," and he starts laughing. He starts laughing because he's got him, and he's now got enough to charge him. And before they charge him here initially and indict him, Your Honor, let's be very clear about what the state knew. They had him under 24-hour surveillance with video out at his place where he's currently being monitored for weeks. They knew what he had for breakfast, what his children had for breakfast, and exactly what he'd been doing all day long. And you'll notice, Your Honor, as part of the indictment here, there's not a single averment that they actually saw him with a firearm or he was doing anything untoward at those times. So, Your Honor, we've got a situation where you've got somebody who was monitored by video by the state for weeks before the indictment came down. And while they might have technically passed the hurdle here of probable cause based upon what a standard that is in front of a grand jury, you also now have the better part of a year of practically perfect performance on electronic monitoring. And now we have dual electronic monitoring, which, Your Honor, under Valdez-Jimenez, I don't see how it increases the safety to the community one whit. But what it is going to do is we are going to have a situation where there is a natural conflict between the state and the federal requirements. My request to the court is give him the more restrictive federal requirements, take off the bracelet, and you still are left with the very large bail that he's posted in this case.
Thank you. State?
So I'm going to start by what I heard as really the thrust of Mr. Klass's argument, which is that there's a conflict between some of the state house arrest restrictions and a conflict with some of the federal court's house arrest restrictions. That argument, Your Honor, is unripe here, because as of this point, the defendant has been put on house arrest in both the state and federal cases. There hasn't been this conflict, and there hasn't become a moment where they've run into problems. If there's a problem, the remedy is for the defendant to put a motion on to address it at that point. But to prospectively say there may be a conflict in the future, it hasn't happened yet, even though he's been on house arrest for months, but it could happen in the future, and so I should be let off of house arrest here. That's an unripe argument and doesn't merit the court's reduction of bail or release conditions today. And the court shouldn't make its finding today based on an unripe argument that may never occur. It hasn't occurred in the months that the defendant's been on concurrent house arrest, and it may never occur up until this point. Secondly, Your Honor, this court has an independent and legally binding obligation to make and maintain a bail and house arrest conclusion in this case, independent of what happens in the federal case. The mere fact that a federal judge has also determined that in federal crimes, house arrest is appropriate doesn't excuse this court from maintaining a bail determination and concluding under Valdez-Jimenez that bail and release conditions are appropriate. Judge Villani and Judge Bell both made findings that this defendant was a danger to the community. There have been hours upon hours of litigation as to this function, and the ultimate determination by Judge Villani was $100,000 bail with house arrest and additional conditions. Just because a federal government several months later has decided that the defendant's crimes also amount to federal crimes doesn't excuse and is not a basis by which this court can remove its ongoing obligation under the law to maintain bail in accordance with the NRS and Valdez-Jimenez. And so the fact that the defendant now says, well, the feds have me on house arrest, so there's no reason to keep me on house arrest, The court should not find that argument availing because it's two separate cases in two separate jurisdictions. Granted, they have a similar nexus of fact, but the law still requires this court to make and maintain a bail finding and maintain bail as is set. It would be an abuse of discretion to say, well, we're going to defer to the feds and allow their house arrest to control our bail setting here. The argument that having two bracelets on the defendant is onerous to him, that he's chafing, I understand that. A lot of defendants say that when they wear the electronic monitoring bracelets, it's onerous, it's chafing. Even when a defendant only has one bracelet, many defendants say they're cumbersome, charging them's hard, they give me rashes. That's not an uncommon complaint with the way these bracelets function. However, the onerousness of house arrest has been brought on because of the severity of the crimes in this case. Because when we look at the facts of this case, Your Honor, despite the way Mr. Klaus portrays the case, what we have is an individual who aligns himself with anti-government extremism, who aligns himself with movements that have called for a violent overthrow of law enforcement and the government, who has obsessively targeted a detective in Metro and a prosecutor, and who has made efforts to intimidate them and to get his supporters in his extremist movements to also ally themselves against these two law enforcement officers for the mere crime of following the law and doing their jobs. And that is a serious issue, Your Honor. When somebody targets police, when somebody targets prosecutors for doing their job, and when they're talking about how blood needs to be shed against law enforcement, how these officers and prosecutors are enemies of the state, that is a true danger to the community. And so when house arrest was imposed in this case, it was done so because two different district court judges determined that this defendant, based on the crimes in this case, is a danger to the community, is a flight risk, and house arrest is the least restrictive means in order to keep not only Detective Meade and Deputy DA Dickerson safe, but to keep the community at large safe. And so to now say, without any change in facts, apart from the fact that there is a separate case in a separate jurisdiction that now hasn't charged on gun charges, in the absence of additional facts demonstrating why this defendant should be released from house arrest, the court shouldn't lower bail now simply because he's got two bracelets on. Keep in mind, Your Honor, the defendant argued and litigated for hours to get to this point where he's on house arrest to begin with. Because initially, Judge Bell found that $1 million bail was the appropriate bail setting. And through Mr. Klaus's hard work and through ongoing hours upon hours of argument in front of Judge Villani, ultimately, Judge Villani concluded that Valdez-Jimenez did entitle the defendant to $100,000 bail with house arrest. But neither judge who previously heard this case, Your Honor, concluded that given the severity of this case, given the threats, and given the defendant's apparent obsession with detectives and with prosecutors, neither one of them determined that taking him off of house arrest would be an appropriate or the correct thing to do. Ultimately, Your Honor, this isn't a relitigation of the three prior bail arguments that have been heard in district court already. Judge Villani heard multiple bail arguments. The state tried several times after superseding indictments to increase bail, and ultimately Judge Villani concluded multiple times with multiple Valdez-Jimenez hearings and multiple 100-page motions that $100,000 with house arrest was, in fact, the least restrictive means that the defendant was lawfully entitled to be afforded under bail in this case. There is no reason to modify it now. There has not been a substantive change in the defendant's disposition that would merit this court to look at the defendant and say he should be released from house arrest, because he should not. Because releasing him from house arrest here would effectively be a concession that, what the feds are doing is going to be dispositive of the defendant's ultimate outcome, and the state case is going to take a backseat to that, and we'll see where the chips fall at that point. I don't know what the federal government's going to do with the defendant's case. I don't know if they plan on taking it to trial. I don't know if they plan on pleading it out. I would imagine, given the evidence, at least on the state side, that they're also looking at this case, appreciating the severity of the defendant's conduct, and would not plead it out to something that would release him. But we don't have any guarantees that's not what's going to happen. We don't know if the federal government is going to plead him out tomorrow, hypothetically, and as part of the plea, agree to release him. And if the court today decides, well, he's on federal house arrest now, so I'm going to take him out of house arrest on the state court, and then the feds plead him out and he's off of house arrest, that's it. He's off of both. And this individual who 2 prior district court judges in this jurisdiction have determined is a danger to the community is no longer on house arrest, is no longer on monitoring, and is effectively free to go back to focus on his ongoing obsession with Detective Meade and DDA Dickerson and potentially imperil their lives. And so this court needs to consider the fact that the 2 cases are separate while factually connected, and the fact that the defendant has a house arrest monitor here and a house arrest monitor in the federal system, those are separate considerations because they're separate cases with a separate determination in this jurisdiction and in the federal jurisdiction that independently concluded the danger to that this defendant has as to individuals who are victims in this case and as to the community. And so for all of those reasons, Your Honor, I'd ask that you deny the defendant's motion to modify house arrest. One more thing I want to talk about briefly. Mr. Klaus has made a lot of saying that the defendant is very compliant. He was compliant in his last case. He's compliant in this case. Ultimately, he was found to not be in true compliance with his probation in the prior case, which is why he wasn't entitled to the drop down. So he did violate that. In this case, Judge Bell found in a superseding indictment that the defendant was in violation of one of her release conditions. That condition was he wasn't allowed to have social media content because part of the case, Your Honor, is that this defendant was the leader of a large social media movement with a lot of followers in his ideology. Judge Bell had ordered that he not have ongoing communication with them through social media. Judge Bell and Judge Villani ultimately found the defendant violated that condition and continued in defiance of that order to go on social media and post about this ideology and rhetoric. So he's already violated some terms in this jurisdiction already based on prior district court's orders. And Judge Villani made an actual order finding the defendant had previously violated a condition of Judge Bell's bail and release conditions. So I don't want this court to think this is a man who's been in perfect compliance. He violated terms in his old case, violated bail terms in this case, and there's nothing to ensure that if the defendant is released from house arrest here, that he's going to continue to maintain perfect compliance and not re-engage in his obsession with these 2 law enforcement officers. So with that, I will submit, Your Honor, and I'd ask that you deny Mr. Klaus' motion.
All right, thank you.
If I might just briefly.
Yeah, Mr. Klaus, go ahead.
I'm sure that if we went back a decade ago, there's probably some things in everybody's background that they did wrong. But the simple fact of the matter is, since Mr. Martinez was last seen by the court on these issues, he has been, and so far as I know, in perfect compliance. There was a difference of opinion as to the extent of Judge Bell's order. It was not directed at Judge Meade. It was a social media post about the fact that he had his own criminal case now. But it was not directed at Detective Meade or DA Dickerson. So reasonable minds differ. He was in violation, but Judge Villani already addressed that condition. There has been no violation since the last time that we were here in front of the court to address his bail conditions. Finally, Your Honor, I'd ask you to remember this argument because we're going to be coming back in front of you a lot, I think, over the next 5 months. And I want you to remember what the state said. This is about the defendant's obsession with DA Dickerson and Detective Meade for the mere crime of doing their job. It's in the transcript. That's what the state's telling you. I think we're going to show you something different. But beyond that, let's talk about the practicalities here. The state's response is, if he gets taken into custody because there's a conflict between these two electronic monitoring programs, well, then we just file a motion. Respectfully, Your Honor, the house arrest EMP program in the 8th Judicial District Court is a bit of a dog's breakfast. I was arguing this in front of the Supreme Court last week, and the 8th Judicial District Court does not even put people on calendar when they are taken in by house arrest personnel, and they are held without bail. And if that happens in this case, My client will be held without bail in the state system, without a hearing being set, until I get around to putting it. Because the state's not required to file a motion. The house arrest personnel aren't required to file a motion. And then once I convince the judge that he was convince you, excuse me, Your Honor, that he was actually in compliance with the federal restrictions that had him going in and doing a drug test, and he violated because he didn't get a hold of his house arrest officer for the state side before he did so, and so they took him in for a technical violation. Once you release him, he's still going to stay in custody until the federal court addresses that, because remember, when the state takes him into custody, they have to snip the federal bracelet as well. And I understand the state's perspective here. They'd love to be able to punish my client before they can convict him, because they might not be able to convict him, and so this is the best slice they're going to get out of him. But, Your Honor, constitutionally, that's not what should happen. What the state should be addressing here is really only two legal bail arguments. The first one is, has there been a new circumstance since we were last in front of the court? And the answer is unequivocally yes. Under NRS 178.499, there's good cause here. There's something new that's happened. He's had a new electronic monitoring bracelet put on his other ankle by the federal court. So that's a new circumstance. You are absolutely within your rights to look at changing or revisiting his bail based solely upon that. But secondly, Your Honor, what at a base level under Valdez-Jimenez, what good, and the state has completely avoided this argument, what possible community good or harm is being achieved by having two electronic monitoring bracelets on his ankle? The state can't tell you, and they didn't tell you in this argument, because they cannot tell you that there's any additional safety that's being provided to the community. If the court wants to put in an order that says, if we take off the state bracelet and later on the federal case gets dismissed, or later on the federal judge removes his federal bracelet, and then I want him put back on state monitoring, absolutely. Absolutely, Your Honor, I'd welcome that order from you. But what I'm saying is there's no good, there's no benefit, there's no protection that's being given to any of the actors here by having two bracelets. One should be sufficient, Your Honor. And don't ask my client to be scarred for life for a case that he hasn't even been convicted of.
With regard to the conditions of the federal monitoring, my understanding is we've talked about the conflicting conditions, but what about as far as his requirements under the state versus the federal?
My understanding, Your Honor, and I gave you as many of those requirements as I had available, they're actually more restrictive than the state restrictions are. In fact, that's why Mr. Martinez is appearing via a phone connection on Blue Jeans, because under the federal system, not only is he not allowed to post on social media, he's not even allowed to have access to the internet. So this is as good as we get. So this is a result of the federal restriction that he's placed on in the electronic monitoring. And it's more than that, Your Honor. All of his phone calls are monitored by the feds. So if he wants to have a private conversation with me, Your Honor, he has to come into town to have it. When I say that they're more onerous on the federal level, they really are more onerous, and you are looking at proof of it on the Blue Jeans connection here today.
All right, thank you. State, what is your thoughts on that?
Again, Your Honor, I believe that this is an unripe argument, because at this point the defendant has been on concurrent house arrested conditions for several months, and there hasn't been a violation yet on either side. Mr. Klass's argument that he's going to have to put a motion on, that's exactly what it means when something's unripe now. Until there's a reason by which Mr. Klass needs to put the motion on, there's no reason for the court to hear it today prospectively, because there hasn't been an injury stemming from what Mr. Klass alleges is going to happen that would merit this court to consider it. The fact that the federal court has conditions that he's arguing are more onerous or more restrictive, again, 2 points. The first is it's a separate jurisdiction, and the fact that other restrictions or terms in the federal or conditions are different from state doesn't obviate this court's obligation to maintain what it's already found in Valdez-Jimenez to be the appropriate bail and release conditions here, and to maintain those conditions here. The second thing is, ultimately, it's possible that the federal government does plead this case out, or that the defendant does get released from house arrest. Conceivably, his attorney in the federal system is going to file a similar release bail modification motion in federal court, and the judge may be more amenable to releasing or lowering bail in that case, at which point the only thing holding the defendant here will be what the state court has already found to be the appropriate level of release and monitoring, which is house arrest here. And so while right now the defendant does have 2 bracelets, that doesn't mean it's always going to be 2 bracelets, and that doesn't always mean that the state case and the federal case are going to resolve harmoniously with each other. And we have an obligation in this case, in front of this court, to make sure the defendant that the victims and the community at large are protected from this defendant.
Understood. What about an order that he's only released from this house arrest so long as he remains on house arrest in the federal case, and that if for any reason that is removed, that the order is already a standing order that he must immediately report and be placed on house arrest in this case?
Your Honor, I think that ultimately that's not an unreasonable position for the court to take. The state believes that its argument about what this court, not Your Honor, but what Judge Villani and Judge Bell have found remain the valid determinations of bail. And so modification is not necessary because we've already had a determination of what is the appropriate level of release. However, if the court has decided that it is going to make a modification, I think that would be the most appropriate, I suppose, resolution if the court decided that that was what it was going to do. The state would oppose that generally because I believe that Valdez-Jimenez has been determined and we have an obligation to maintain that prior order in the absence of full-blown reconsideration of bail. But I understand the court's position on that.
Okay, all right. The court finds that, first of all, there has been a change in circumstances, and although I obviously have utmost respect for all of the work that's been done in this case in front of both Judge Villani and Judge Bell, and the utmost respect for their decisions and rulings, I do believe that him being put on monitoring in the federal case is a change in circumstances that has prompted an appropriate re-review of the Valdez-Jimenez and prior bail sentencing. I also believe that this concern that there are conflicting requirements or at least procedures and policies with regard to the federal house arrest and the state house arrest is ripe for consideration now. I do not think that the accused needs to first be arrested in order to make it ripe. I think we can clearly see what the potential issue is, and that potential issue could result in weeks or months of incarceration of the defendant, even though he hasn't done, technically anything wrong, other than by trying to comply with one house arrest, he is unable to do so without violating another house arrest. So I do find that concern is ripe for review. And all that having been said, I believe that the double house arrest is not appropriate, that for the reasons I just stated, it sets the defendant up to ultimately be arrested, and that it's not only that, but as far as it doesn't enhance the protection of the community or any of the parties concerned whose safety is of concern in this case, that being on one or the other sufficiently protects. And substantial proof of that is that he was on one, and that was determined to be sufficient. So at this time, my order is going to be that he's released from the house arrest in the state case, but only so long as he remains on house arrest on its current terms with no changes in the federal case. If that changes for any reason, there's a standing order as part of this order that he has 24 hours to report to Nevada house arrest program to be placed back on house arrest under its current conditions. Is there any clarification needed?
Just that I was being yelled at by Martina Bauhaus yesterday, Your Honor. It's EMP. It's EMP. It's EMP, Your Honor. It's EMP high level is what this was Ms. Bauhaus's contention. So stop calling it house arrest. It's EMP house arrest. So if we're gonna, I say that somewhat jokingly, Your Honor, just if we're going to be reflecting it in the order, I just request that it's be the electronic monitoring program and the federal electronic monitoring program.
Yes, he is released from the state electronic monitoring program as long as he stays on the federal electronic monitoring program under the exact same conditions that they are under now. If anything changes, he has to report to the state of Nevada within 24 hours to be replaced on electronic monitoring program.
Thank you very much, Your Honor.
All right, thank you both very much for all your work.
Your Honor, just as one more point of clarification, the court is not modifying any other release conditions, correct?
No, bail stays the same. Everything else stays the same.
Understood. Thank you, Your Honor.
Thank you.
Thank you very much, Your Honor.